for a third contempt. Why did you not appear in September?
Your Honor, first I would ask the court if he wishes to request appointed
You
counsel.
want to do that first?
Yeah, I don't want to ask him questions under
Before.
oath before he's got counsel.
Thank you, sir. Thanks for the reminder. I'm going to backtrack a little bit, Mr. Wilson. Because there's a possibility of sanction that could include jail time for a third contempt. I got ahead of myself. Do you wish to be represented by counsel?
No, I'd waive counsel.
All right. Is anyone forcing you to do so?
No.
Okay. And you understand that if you change your mind at any time, you can always tell the court that you request counsel?
Yes.
All right. Thank you, sir. Mr. Wilson, can you tell me why you did not appear in September?
September, there was a couple times I was in the hospital. The 14th, the day before my birthday, I believe I was also in the hospital. I do recall getting served the papers. So I really don't have I mean, it was my responsibility to be there, and I failed to appear.
Thank you, sir. Mr. Loving, any comment?
Your Honor, we've had some difficulty with this defendant in that he has been denying that the debt is his after having been established multiple times in the past. We believe that he is just attempting to avoid the debt. We would ask the court to find him in contempt and sanction him to a period of jail consecutive to his current incarceration for a period of at least 24 hours at the court's discretion.
You said consecutive?
Consecutive, yes, Judge.
All right.
Sorry, concurrent to.
Concurrent.
No, sorry.
Thank you.
Thank you. Consecutive after, yes, thank you.
Okay.
I haven't done criminal court in a while, so thank you.
All right, Mr. Wilson, Mr. Loving has provided information to the court as well as yours, and the court will find you in contempt for the third time. Grant the plaintiff's motion for a 24-hour jail sanction to be served consecutive, which means after your release from whatever charges you are on, an additional 24 hours will be tacked on for the contempt. Do you understand that, sir?
Yes, Your Honor.
All right. And I know you started to say something while Mr. Loving was talking. What did you have anything for the court regarding where we're at on this debt?
No, I don't.
All right. Mr. Loving has informed the court that you've not accepted responsibility for that or have attempted not to, and he's telling the court that it's been verified this is your debt. Sir, is this your debt?
Your Honor, I was incarcerated in Winfield Correctional. I was in the KDOC whenever the services of this debt was acquired. So no, this is not my debt. I just was not there to get, you know what I mean? The judgment got put against me because I wasn't there I wasn't there for the courts.
When did you enter KDOC, sir?
2012.
Okay, that's when this debt was incurred, was in 2012. Judgment was rendered in 2013. That's where you're getting confused. This was from a period before your incarceration. I understand that you probably weren't able to pay the bill because you were incarcerated. However, the debt was incurred before your incarceration. Judgment was rendered after your incarceration.
You're incorrect, and I'm not trying to argue with you, but I could tell you who acquired the debt in my name, and it was not in my name because I wasn't there to do it. I was incarcerated. I was incarcerated in here and in Winfield, and I didn't get out until 2015. I'm 100% sure of that, and I could tell you that it was Maricela Vargas that got that service in my name.
Well, previously you'd been saying that this was your father's debt who passed away.
I wasn't saying that. I've never showed up to court for any of this.
Well, that was the discussion that you had with John Craig, the previous attorney on this matter.
I've never had a discussion with anybody on this matter. The first time that I contacted you guys, I wrote you a letter last week about it.
Yeah. Well, that all is moot because this judgment was rendered and final.
My father is not dead.
Sir, so the judgment was rendered and final in 2013. Any attempt to appeal or to set aside has long passed. This judgment is now yours, sir.
Yep.
Okay. Mr. Wilson, to move this matter forward, we've handled the issue of the 24 hours for the contempt. Mr. Loving, what do we need to do? What do you need from Mr. Wilson to try to get this matter moved to resolution?
Well, I understand that, of course, while he's incarcerated, he's not going to be having an income. We would ask the court to order him to provide us updated contact information for him within 7 days of his release from incarceration. We would ask the court to also order him to provide us employment information, proof of employment within 7 days of him obtaining employment. And then at this point, we would just ask for an order back for 12 months from now. Mr. Wilson, do you know your expected date of release?
March 16th.
Thank you.
March 16 plus 24 hours. So. Very well. What is the date you're requesting back? Are we going back to that January 9th docket?
Since he's going to be out in March, let's do 6 months. I can give you that date. Yeah, just a
Is that a
second.
July date?
That is going to be July 11th at 2:30.
All right, Mr. Wilson, at the request of plaintiff, the court is going to order you that within 7 days of your release from incarceration, notify his office of current contact information, that being correct mailing address, phone numbers, email addresses, ways that you can communicate with his office. In addition, I'm going to order you to provide proof of any employment you get after release to Mr. Loving's office within 7 days after gaining employment.
Okay, I filed disability, so do I just bring the application for my disability? My application, yeah. I can do that.
Not the application, but the award letter.
Okay.
And then finally, Mr. Wilson, the court will order you to return on July the 11th, 2024 at 2:30 p.m. To see where we're at in this case, and that will be on another judge's docket that day. Do you understand that, sir?
Yes, Your Honor.
Any questions about any of my orders, sir?
No.
Very well, Mr. Loving, anything further?
As you're going to be there until mid-March, we're going to go ahead and send you a copy of the journal entry from what happened today to the jail. So you've got a copy of it for your records. You've got those dates and those requirements, okay?
Yep.
All right, nothing further, Judge.
If nothing further, we are adjourned. Thank you for your appearances. Ms. Ridgway, can you hear me?
Yes, Your Honor, I can hear you.
All right, Mr. Loving, I'm going to jump to Ms. Ridgway and an individual that's been on Zoom for a little bit.
Certainly.
Give me one moment. Mr. Rowmaker, can you hear me?
Yeah, I can hear you.
Thank you, sir. Mr. Rowmaker, this is Finney County District Court case 2005 DM 110. And Mr. Rowmaker, you were listed as the defendant. I know we've been trying to get everybody together on this since September. We now have all the players in place where we can try to move this along. Are you having any trouble hearing or understanding me, sir?
No, I can hear you.
All right, Ms. Ridgway, would you like to inform the court as well as Mr. Rowmaker what we're doing today?
Yes, Your Honor. Essentially, a bench warrant was issued back in June of 2016 due to Mr. Rowmaker's failure to appear. That warrant had remained unserved and was eventually recalled by the court in September of 2023, and the matter scheduled for today's hearing. There's been contempt actions pending against Mr. Rowmaker for essentially decades, Your Honor. The children emancipated in 2018 and 2021. His last actual payment was in 2017, so prior to the emancipation of either of the children. And he owes $43,446.39 in support arrears. I will advise the court that in May of 2020, we did receive $1,200. That would have been his COVID stimulus payment. And in July of 2023, we received 2 payments from a state income tax returned. Those 2 payments total less than $5. not each, but combined.
Very
And
well.
that has been his payment history for the last 7 years.
All right. Mr. Rowmaker, Ms. Ridgway is telling the court that you are in arrears of quite a bit of money. And I guess what we need to do is figure out what you're able to do and willing to do to get this resolved.
Well, what do you got in mind?
Well, as far as the court goes, some regular substantial payments would be a great start.
Now, yeah, I mean, heck, yeah, that would be a great start. But something more practical. I mean, I mean, I don't have, money. I don't have a money printing machine
Okay.
as much as I would like to.
Well, the court finds payments towards a debt to be a practical attempt at solution. So I guess, Mr. Rowmaker, are you currently working?
No,
All right. Are you looking for work?
yes, I am.
Okay. Ms. Ridgway, how do you want to approach this at the present time?
Well, Your Honor, when the children were minors, the child support obligation was $375 a month. Looks like when he last was making some regular payments. Well, we had a couple of months in which he paid at least that month that much. I would be agreeable to accepting $200 a month towards this debt. The debt is really extremely high, and he's made absolutely no efforts to pay in 7 years. I think $200 a month is very fair.
Very well. Mr. Rowmaker, are you able to make $200 a month payments?
You know what? At this time, no, I'm not. I mean, I mean, right now as it is, I'm living hand to mouth. I mean, it's not. I mean, I mean, you can't really you give what you ain't got. I mean, I don't
I
know
understand
how.
that, sir. So let me explain to you what I'm getting from the court's notes. This was a bench warrant that had been in effect for your arrest was called in September based on certain promises for you to appear. There have been some hiccups in you appearing on the dockets that you were scheduled. I've been informed by DCF attorneys that you've made contact with them after the fact, but yet nothing's getting resolved. The bench warrant was recalled based on you performing certain duties or accepting some responsibility for things you need to do. So that bench warrant was recalled, but it can be reinstated. So my question to you, sir, can you make $200 a month payments, or can you come up with bond to get out of jail?
Well, well, I mean, I'd go to jail for the debt. You're saying? Is that what you're saying?
Well, the contempt of court, you've had several times that you didn't follow through on things you were doing. I'm only asking this as a hypothetical right now because sometimes people tell the court they can't make minimum payments, but they can sure come up with $500 or $1,000 to bond out of jail cash. So what I would like to do, I would like for this to work out so that doesn't become a problem. So what can you pay per month, sir?
Well, I mean, how about I mean, I can. You know what? I mean, I could try to do how about $100 a month? I mean, that's something. I mean, I can try to do that, and and I'd like to do more. Believe me, I'd like to do more, but I mean, that's what I can offer. I mean, that's
Okay.
Your Honor,
as is.
Ms. Ridgway, what are your thoughts?
I would propose $100 a month, beginning with the month of February for 6 consecutive months, and then $150 for 6 consecutive months, and give him a full, then 12 months to get to the $200 rate. And I could include that in those steps in the journal entry if the court was agreeable.
Okay, Mr. Romaker, the court is agreeable to that. Is that, if you said you do $100, can you do that for a minimum of 6 months and then we'll increase it while you're gaining employment?
Yeah, I can do that.
So we're in agreement, then we will leave the bench warrant recalled rather than reissued, and you make those payments as per the agreement, 100 for 6 months, 150 for 6 months to get to the total. And then Miss Ridgway, we probably need to get this back on the child support enforcement docket where it belongs.
Yes, please.
Do you have the January 2020? Well, you probably don't have the January 2025 date because let me
Well,
check it.
yeah,
ahead.
I don't want to give him a whole year before we bring him back to court. I'd like to review it again in maybe 3 to 5 months, just to make sure that these payments are actually being made.
All right, I think 3 months is reasonable. And I
Okay, now-
have April 10th. Is that what, do you concur, Ms. Ridgway?
Yes, that would be fine, Your Honor. Is that at 9 o'clock as well
Yes.
by Zoom?
Zoom is acceptable if payments are being made. Mr. Romaker, did you hear that?
Yeah, now, is my appearance necessary if the payments are being made?
No, here's what I'm telling you is I'm putting this on the child support enforcement docket for April 10th, 2024 at 9 a.m. You will need to appear at that date and time. We will evaluate where you're at. You may appear via Zoom. However, if problems arise, future appearances may be required of you in person. Do you understand that, sir?
Yes, I do.
So it's contingent on you maintaining this agreement that you've entered into and that the court has ordered. Do you understand, sir?
Yes.
Any questions about anything we've discussed?
Well, well, no, I guess I don't have any questions. No.
Very well.
Mr.
Ms. Ridge-
Romaker, do you know how to make the payments? Do you have the mailing address?
Is there a way that I could send it more efficiently instead of like through the mail?
Well, do you have access to the internet?
Yes.
If you would go to kspaycenter.com, there are a variety of ways available to make an electronic payment. There's Apple Pay, Google Pay, Venmo. There's a list of various convenience stores that you go take cash to, and they'll make an electronic payment for you. It's called Pay Near Me. So there are a variety of options on that website, but there's also the mailing address.
Okay. Yeah, I remember using that Pay Near Me before for this
Okay.
for this exact thing.
They
So,
do
yeah.
charge a
Okay.
fee for that, but it's
Yeah.
reasonable.
Okay. Yeah.
All right, Judge, thank you very much.
Thank you. If nothing further, we are adjourned until April 10th, 2024 at 9 a.m. But we'll see you
April
then,
10th.
Mr. Romaker.
Okay. April 10th. Thank you.
Thank you, Judge. May I be excused?
You may. Thank you.
Am I done?
You may too, Mr. Romaker. Thank you.
Okay. Okay. Thank you.
All right, Mr. Loving, we're back to your docket. Who do we have next?
We have 2015 LM 516, Wyoming Financial Lenders, DBA Money Lenders, v. Olivia Jasso. And Miss Noah, formerly Jasso, is here today.
All right. Good morning, ma'am. Let me find you on my docket.
And she is here for a bench warrant for failure to appear at citation.
If you have Christina Felix on the bottom.
Right above her should be Olivia Jasso.
Okay, gotcha. Thank you, sir.
So this is from a failure to appear in March of 2021 for a hearing in aid of execution. That was served residentially 6 days prior to the hearing. And then personal service on the citation to appear was had on April 30th of 2021 for the May 2021 docket. She failed to appear at that hearing, and a bench warrant was issued with $500 bond. She has been served and bonded out. She has been served, but she was arrested and bonded out. And additionally, this is her first failure to appear. So we would ask for 2 findings of contempt, one for the HIA and one for the citation, and no sanctions at this time. We would also ask that the $500 bond be forfeited to the debt. And then to proceed with an HIA, Judge.
All right. What did you say your now name is, ma'am?
Noah, N-O,
N-O-A-H, N-O-A-H.
yes, N-O-A-H.
All right. Miss Noah, did you understand what Mr. Loving is telling the court?
Yes,
All right. He is asking for some findings of contempt, but before we get to that, I want to ask you some questions. So I'm going to ask you to raise your right hand. I'll swear you in. You solemnly swear that the information you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes,
All right. Ms. Noah, that Mr. Loving laid out 2 separate incidents where you were served to appear for court and did not appear on, okay, do you have any recollection of that? Or any reason why you,
I remember getting served once. I do not remember why I was not here. I don't remember the second time being.
okay. Very well. Well, the court has it in its file, in Mr. Loving's file, that you were served, you were to be here, and you were not here. So the court will find you in contempt for the first time twice, order no sanctions. I will tell you that contempt findings are cumulative. If you never have another, there's basically no harm, no foul, except for a checkbox on this record. However, further failures to appear, second and third, can have consequences, including monetary or potential jail sentence. So they're not something to take lightly, okay? In regards to the bond that you posted, Mr. Loving is asked that be forfeited towards your debt.
Okay.
Do you have an objection to that?
No,
Very well. Then the court will order that bond be forfeited to the debtor.
Creditor.
I'm sorry, creditor. That's what I get for trying to speak and write at the same time. So at any rate, and then Mr. Loving, what do we need to do to keep this matter moving forward?
I'd like to do just a brief hearing aid of execution and then an order back for probably 12 months, depending.
12 months being that January 9th date?
Well, depending on what information we get out of the HIA, yes.
Okay, let's do that. You are sworn. Mr. Loving's going to ask you some questions. Mr. Loving, do you want to go to another area? Do you want me to clear the courtroom for